Oh, hello. I didn't see you there. I was just reading some legal documents. Hi, I'm Matthew Leffler, the armchair attorney, and this is a Blitz edition, quick, coming live. There's something deeply cathartic when you start to record something and stream it, knowing that likely no one sees it. Maybe someone does at some point, and your twins are upstairs sleeping, so you can't get too animated. But regardless, I wanted to do a short video to complement or to add on to what I previously wrote about in the litigation between MyCarrier and Project 44. This case is interesting. There's things at play that require a deeper dive. And I like to talk. It's so much more interesting to talk about these cases than to write about them, though writing about them is also pretty interesting. So what's happened? What is going on? What is the big thing, if there is a big thing, we should know about? Well, this came down on March 3rd, 2025, 2 days ago. At issue, as it sits in the Delaware Court of Chancery. For those of you who've been following us for a minute, the Delaware Court of Chancery is like the Madison Square Garden of business disputes. This is where real stuff happens in the world of business and litigation. Oh, to be in Delaware. Now, I don't have a lot of flashy graphics. I don't have a lot of text that I'm going to pull in front of you. What I'm going to do is tell you a story. And it's a story about promises made, promises kept. The business of transportation, like the business of everything, is predicated on people honoring their agreements, to sign something and agree to something, knowing that you will be bound by those terms and conditions, even in the case that you don't understand them. But this is not about unsophisticated parties. These are parties that are well represented. And so we talk about the agreement. What did MyCarrier and Project 44 agree to do? Now, that is a complicated and interesting question. At its core, Project 44 serves as a toll road, a connector of all the things. There's a reason why the handle on X is freight pipes. It's connecting different systems, taking device information and making that available to other people to consume. APIs. We talked about those before. I remember the letters, though. Don't ask me what they stand for. I'm just a humble country lawyer. But what happens in this case is MyCarrier comes and says, I would like to work with you, Project 44, and our agreement will prohibit certain things from happening. Increases of the price of the API calls. Maybe those are locked in over a period of time. But two provisions are particularly important. And the two provisions at issue have to do with a thing called disintermediation. That's a fun phrase of saying replacing somebody. So in a real context of this, the contract says you are not allowed to make something that competes with me. I will give you the data that you want, access that you need for the customers you are trying to serve. But make no mistake, if you try to replicate and replace me, have a standalone product, that is a breach of our contract, our agreement. It is a breach of the promise that you made. Similarly, there's restrictions of who, MyCarrier can go to if they don't want to work with Project 44. Under the contract, it stipulates that you can't just pull out and go somewhere else. You have to deal with that contract. That's the central issue. As we talked about in a previous live video, I think it was live, who knows at this point? Everything's a blur. Who knows if I'm even live now? Maybe this is pre-recorded. Anyway, back to the task at hand. What happened previously was that MyCarrier and Project 44 had an agreement, and the agreement was keeping this connective DNA connected together at a price that was, let's call it, very favorable to MyCarrier, not meeting the revenue and margin goals necessary for a company like Project 44. But they kept it low for a while. But times are changing. People need to raise prices on things. Everyone has to make a dollar. And when MyCarrier understood that the pricing for the connectivity of the APIs was going to increase, it began a project, a proxy project, we'll call it. That's what the court certainly does. And in this proxy project, the discussion becomes not really how do we navigate this relationship with Project 44. It's a question of how can we remove them from the equation? What steps must we take internally to be able to go around or remove them from the conversation? Well, Jet McCandless, CEO and founder of Project 44, learns of this proxy project. And he says to the folks at MyCarrier, I believe what you are doing violates our contract. You ought not to do that. But things march on, people get busy, and it seems that that was not stopped. However, the folks at MyCarrier became concerned. Will they pull the plug? If Project 44 believes we are in breach, could they turn off the pipes? Data is a utility, and if you lose access to the utility, can you stay in business long term? Who knows? And so the folks at MyCarrier sued Project 44. They began a fight that they were not going to be able to win. They sued in the Delaware Court of Chancery, the Madison Square Garden of business disputes. And in this litigation, they say to the court, please, please, don't let them pull the plug on the data. We need that data. If you pull the plug on the data, we will suffer irreparable harm. Ah, that's a term of art. Plant a flag in that. We'll come back to irreparable harm. Well, fast forward, an agreement is reached. If the folks at Project 44 want to turn off the juice, they have to give 5 days notice. And the team at MyCarrier must not work on their electronic bill of lading product that they were working on in the LTL space. This is when it gets interesting. This is when we see the influx of all of the litigation, the discovery, to figure out, okay, what were you trying to do, MyCarrier? What was your goal? Was your goal to do a one-off, or was your goal to disintermediate us? And it became quite clear through the evidence, and the court talks about in their opinion, that it seemed very clear that MyCarrier had a goal of breaking the contract. Their goal appears from the context and the discovery that they were going to get away from Project 44 one way or another. And this is when the litigation begins to come to a head. What was being asked in this case? What was being asked, or what were the promises that you made? And did you keep those promises? And if you didn't keep those promises, what is my remedy? How am I made whole if you breach the contract? Now, for you non-lawyers out there, and I'm sure most people who listen aren't lawyers, some of you are, what you look at is an offer, an acceptance, consideration, payment, and performance. You perform under the contract. That is how you do contracts. You make a promise and you follow through. What we see in this case is that the promises were not kept. The evidence was fairly clear that MyCarrier intended to break this contract, whether it was through this movement to another provider, a competitor to Project 44, or whether it was to simply build it themselves. But the reality was they didn't have the resources, the time to replace P44. They could not do that in the time that they had allotted. So instead, they make this partnership with SMC3. It's a company, I guess. Maybe you supply chain folks know all about them. I'm fairly new to the visibility space, but I'm humming along. What is asked in this case? What people are reading about is an injunction. Now, in the world of law, you have 2 paths that you can explore. One path is a remedy at law. The remedy at law is money. That is how you solve problems. is you have money you pay for. The other way you solve a problem is when you have equity and you use equitable means. A judge makes an order and says, you can't do that. You stop doing that. But injunctions and equitable relief is still tied to an underlying breach. That's what we're talking about, the underlying breach. And so this case walks us through 34 pages of wonderful legal opinion, what actually happened. Now, I've talked about that in other places, and I won't belabor the point here, but it is clear through the evidence that it was more likely than not that MyCarrier was going to break that contract. And in fact, likely broke the contract in two places. One place was to try to build behind. So you make something and they make something to compete with you without you knowing it, or to divert to a competitor, which you are not allowed to do. This is a contract negotiated with lawyers to make sure everybody knew exactly what they were getting into. Companies do not enter contracts like this without having representation. This is not a question of an individual person giving a non-competition agreement or something similar. This is sophisticated entities negotiating a certain thing that happens. And when one of the entities understands that the other entity is lying or is breaking the contract, is not honoring the promise that they made, what do you do? Remember, MyCarrier started this fight. They sued Project 44 in Delaware Chancery Court to force them to not turn off the juice. And it continued along. And what Project 44 was asking for, what this order talks about, is whether Project 44 could win an injunction against MyCarrier to prevent MyCarrier from going and working with a competitor. And that injunction was not granted. What are the grounds for injunction, you ask? Well, that's a great question. It's a legal question. And I'm going to read this from the opinion. Quote, to obtain a preliminary injunction, a plaintiff must demonstrate, 1, reasonable probability of success on the merits. 2, that they will suffer irreparable harm or injury if an injunction is not granted. And 3, that the balance of equities favors the issuance of an injunction. Those are the 3 elements to win a preliminary injunction. You should defeat any single one of them, the injunction fails. Injunction stops. Equitable relief is a special type of relief. The belief of what we talk about in equity is that if it doesn't stop now, there will be irreparable harm. You can't unring the bell. You can't get the horse back in the stable. You can't put the toothpaste back in the tube. That is irreparable harm. But if you step back, the very first part of this preliminary injunction is a reasonable probability of success on the merits. What are the merits? That there was a contract, legally enforceable contract, that there was performance, that someone else didn't perform and resulted into a breach. That is what this case boils down to. It boils down to a relationship between sophisticated entities that negotiated this particular deal, knowing full well that MyCarrier was not in a position to attempt to disintermediate Project 44. What happens next is arbitration. Arbitration is a way of taking this litigation that's happening now and bringing it somewhere else, a different forum to litigate or contend with these allegations. What Project 44 has been successful in showing is that there is substantial evidence, as the court noted, a reasonable probability that Project 44 will succeed on these breach of contract claims. So the injunction, the asking to stop them from working with a competitor, that's not what the issue is. That was some relief that was asked for and briefed and litigated. But ultimately, the underlying issue is, were the promises that were made kept? And if they weren't kept, what are the damages? That is what we will maybe learn in the arbitration process, but Generally speaking, arbitration is private. It is confidential. It is not open to the public. So we may only see this. This may actually be the last thing we see in the MyCarrier and Project 44 litigation. But it is a cautionary tale for business owners and entrepreneurs and data people and really everybody. The best predictor for future behavior is past performance. How have you behaved previously? That informs how I understand we work with going forward. Promises made, promises kept. It takes a long time. It takes a long time to build a reputation that you honor your word. And when it's found out that you don't, how does that change the dynamic? What do you do if you're a software company dependent upon other software companies? How do you negotiate your position where you're not boxed in perpetuity? MyCarrier will continue along its path with SMC3. They will continue to work with them as the new piping for the technology. The damage that Project 44 suffered in terms of this court wasn't irreparable. It's money. It's always money. But there was no need, there was no ability, there didn't meet the criteria for asking a court to say, do this thing or risk falling in contempt. Oh, injunctive relief is interesting. But again, it's relief. It isn't the claim. It isn't the merits. And we have a little way to go before we fully understand what is really the damages we're going to find. But we go back to the very beginning, as everything does. An agreement between people. An agreement between people that spells out how do we work together and how do we not work together? How do we pull that ripcord and move somewhere else? And when people get in the way of themselves and create these points of friction, it's only a matter of time. Whether you're litigating in Delaware Chancery Court, you're litigating on the internet, or you're just having that private conversation saying, hey, I had different expectations of what our relationship was going to be. And it seems that you went a different direction without telling me, and it might be the case that you've broken the contract. Oh, time will tell where this all ends out, but this story is one that we will see and we have seen for a very long time. Promises made, promises kept. That is the story of the modern supply chain. You are only as good as the last time we collaborated. Memories in this business, they can be long, but they also can be reimagined. I appreciate everybody who's written to me or asked me to talk about this case. I find it fascinating. I still to this day, I find it baffling that anyone wants to litigate against Project 44. I mean, we just saw four kites go all the way to the Illinois Supreme Court. That's wild. That's wild. But if there's a law, if there's an intersection of that law with the world of logistics and transportation, I certainly hope I get to learn about it. That's it for today. Quick little 20-minute vignette, we'll call it. I will link a couple things to this if you're curious to learn more. The case is brand new, fresh. I doubt we'll see appeals, but anything's possible. It's law, after all. Supply chain. So as we continue to think about tariffs and all the things that might happen with that, just remember, you can't opt out of the supply chain, and you certainly cannot opt out of the law. I will see you next time, maybe at TMC. I hope you go there. Anyway, have a great rest of your day. As always, I appreciate your support and your spending a little bit of time with me. That's all for today. Matthew Leffler, the armchair attorney, adjunct law professor at Michigan State, father of four, twin dad. Oh, the list goes on. And actually, maybe you're going to see an article of mine tomorrow in Freight Waves. That's a teaser. You're going to see an article tomorrow. I hope. Thanks for joining me. Yeah, that's it. That sounds right. That's very nice of you. I appreciate that. I don't say this often enough. I really don't. I hated the way that I sounded when I was a kid. I hated. I had vocal nodules and I had a really bad stutter. And so I sounded like a mixture of Donald Duck and Porky Pig. It was not great. But my hope, as I give my students, I give to all of you, is these things that happen, this stuff, it's a lot. There's a lot. But it's not outside of your ability to grasp it. Certainly not. And this certainly something that, if you understand it, can help inform things that you'll do, choices you make. Nothing is above your pay grade. You have so much power, you don't even know. And so if I have the opportunity to take something that may seem a little bit wonky or esoteric or silly, it can be useful to you. That's why I do what I do. And I'm grateful for the opportunity to come hang out for a minute, talk about the law, talk about litigation. I'm going to do one of these tomorrow about Pink Cheetah. I think Ken's going to like it. Let's have some fun, everybody. Have a good rest of your day. I'll catch you eventually on the Armchair Attorney Podcast. Brought to you by, who is it? A floating disembodied head. Yes, floating disembodied head. Ask for it by name. And of course, one of our early sponsors, medium-sized dogs. Medium-sized dogs. Dog of choice for most people. That's right. All right, we're done.